Welcome to our session on safeguards. These measures are often grouped together with anti-dumping measures and measures WTO members may take against subsidized imports. However, in contrast to so-called unfair trade practices or to these unfair trade practices, safeguards do not require any type of unfairness. All that matters here is that there is some justifiability of measures to protect your domestic producers from a threat or an actual injury caused by a sudden and unexpected surge of imports. So this surge might be either a real increase in imports, so an absolute increase, the absolute numbers are higher, or there is a relative increase, so the imports share in a shrinking market have increased because the market itself has become smaller. But what is not required here is, in contrast to dumping and subsidies, that a WTO member or producers from a certain WTO member resort to some practices, for example, to drive out local competitors of the market to gain a dominant market position, as in the case of dumping, or because a WTO member tries to make up for opening its market by supporting domestic producers with subsidies to make them more competitive both at the domestic and at the global level. This, however, is not required when it comes to safeguards. What are the sources of all of these rules allowing WTO members to resort to, on an exceptional basis, measures to combat or to protect their markets from a sudden surge of imports? Article 19 of the GATT from 1994 and the 1994 Agreement on Safeguards. The latter also prohibits so-called gray area measures. What is a gray area measure? These are measures that have been negotiated bilaterally outside of the WTO framework, where exporting countries have been persuaded to restrain their exports voluntarily. Why am I using parentheses here? Because voluntarily is not always stricto sensu voluntarily. There might also be political economic pressure being put on producers, on companies to restrain their exports if a more powerful country says that, wait, we want to convince you, and there are sometimes offers you can't refuse, convince you to limit your exports to our country because you're harming our producers. Or there might be other means of sharing markets that can be subsumed under the notion of gray area measures, but however they are also prohibited by the 1994 Agreement on Safeguards. And older gray area measures, so pre-existing ones, also have to be phased out as enshrined in the Agreement on Safeguards. The starting point for our debate, however, is Article 19 of the GATT, titled Emergency Action on Imports of Particular Products. So here you find the general preconditions necessary to be fulfilled in order to resort to safeguards. And it holds that as a result of unforeseen developments and any product is being imported into the territory of a WTO member in such increased quantities and under such conditions as to cause or threaten serious injury to domestic producers in the territory of a WTO member to like or directly competitive products. So this is somewhat similar to what we've discussed in particular in connection with Article 3 of the GATT concerning national treatment. And then, however, if that occurs, so unforeseen development, increased quantities of like or directly competitive products, then a WTO member is free in respect of such a product and to the extent and for such time as may be necessary to prevent or remedy such injury, to suspend the obligation in whole or in part, or to withdraw or modify the concession. So what does that mean? For example, quantitative restrictions may be imposed. Usually they are prohibited, but if a safeguard is necessary and justified, they may be on a temporary basis allowed, or they may impose higher tariffs than the tariffs they have bound themselves to in their schedules of concessions, which, however, are binding and obligatory under Article 2 of the GATT, but nevertheless, in exceptional circumstances, higher tariffs are still lawful. Then Article 2 of the safeguard agreements lays out certain conditions. So, a member may apply a safeguard measure to a product only if that member has determined that such product is being imported into its territory in such increased quantities, and here again absolute or relative to domestic production, and under such conditions as to cause or threaten to cause serious injury to the domestic industry that produces like or directly competitive products. And again, here the source is irrelevant. What matters is the impact of these increased quantities on a given market and also on the producers in a given target market. So, however, first you need an investigation on that. That leads us to Article 3 of the Agreement on Safeguards, where you need competent authorities to conduct such investigations in accordance or in consonance with Article 10 of the GATT, which lays out certain transparency or, more generally speaking, rule of law obligations. And what you also find here, the requirement of including reasonable public notice to all interested parties, so in particular the exporters, but also the importers, and public hearings or other appropriate means where importers, exporters, and all other interested parties could present their evidence during such investigations, and also they have to be allowed to submit their views, for example, to show whether the safeguard is indeed taken in public interest, so as to protect, and it's necessary to protect the respective affected domestic industry. And then, last but not least, the findings of these authorities also have to be published in a report that includes reasoned conclusions on all pertinent issues, both of fact and of law. And this is to be found in Article 3, Paragraph 1 in the Agreement on Safeguards. And then in Article 4 of the Safeguards Agreement, you have certain definitions. First, of serious injury, that is here defined as a significant overall impairment in the position of a domestic industry. And then also when it comes to the question as to what exactly constitutes domestic industry, here this is either the producers as a whole of the like or directly competitive products, or those producers whose collective output constitutes a major proportion of the total domestic production of those products. Major proportion does not necessarily mean more than 50%, but a certain market share is necessary. We may have long debates how big the market share needs to be, 20 or 30%. It all depends on a case-by-case basis assessment. So then safeguard actions themselves, what obligations are relevant here? They have to be applied only to the extent necessary to prevent or remedy a serious injury and to help the concerned industry to adjust. So as you can see, and this will be discussed in a few minutes, they are not meant to be applied on a permanent basis, but only temporarily. Then, if a WTO member applies quantitative restrictions, so as you may know by now, the WTO and the GATT, they do not like quantitative restrictions, only on exceptional basis, and also in particular quantitative restrictions of imports. That's a big no-go. But they should, however, not reduce, if they are applied provisionally as safeguards, not reduce the quantities of imports below the annual average for the last 3 representative years. So what does that mean? Remember, it's about a sudden and unexpected surge. It doesn't mean that you have a problem with any surge or with moderate levels of a surge of imports. In addition, imports from a particular country should not be targeted. So what that means is that if you have several supplying countries or several producers from different countries, then quotas, if they are being imposed, they have to be allocated on the basis of previous market shares, for example. But again, no discrimination, because what matters here is the threat or the actual injury caused among domestic producers, but not the question as to which producer or from which country the producers are from causing such an injury or threatening such an injury. So once again, here the level of unfairness, as I emphasized at the beginning and I'll emphasize it once more, is irrelevant. Next, as I've said already, they shall not be permanent but only on a temporary basis, so no longer than 4 years, and they may be extended for a maximum amount of 8 years, but nevertheless during this time they should be progressively liberalized. And last but not least, those members whose producers are being affected by safeguards can nevertheless retaliate. So they can answer, they can react to safeguards with their own safeguards. And this leads me to a particularly interesting case from today's perspective, namely US safeguard measures on steel. You may have guessed it already. Why it is so interesting? Because Mr. Trump has imposed tariffs of 20% on foreign steel, and he has justified these tariffs, and they are prima facie a violation of WTO law, on the basis of the national security exception. Why are they a violation of WTO law? Long story short, the US has committed itself in its tariff concessions, in its schedule of concessions, to impose only 0 to some 2 or 3% on foreign steel. However, 20% is obviously enough, more than 3%, so he has to come up with a justification for these high tariffs. And he could either have resorted to safeguards or, as he did, rely on the national security exception. So he said that, and the argument prima facie is not completely logical. He said that, and I quote, "Steel is steel. If you don't have steel, you don't have a country," end quote. What did he mean by that? If there was no US steel industry, or at least not a competitive US steel industry, or not one able to produce sufficient steel inside of the US and also to supply the US military complex with sufficient amounts of steel, then you have a national security problem, because then you can produce tanks, you can produce missiles and every other military equipment you could think of. However, the US is not even close to not having any steel industry at all, so the argument is pretty far-fetched, and many wondered, or you might wonder, why he did not resort to safeguards. And the simple reason is that the US was already there during the Bush era, so the predecessor to the predecessor of Mr. Trump, George W. Bush, and he imposed steel tariffs on the basis of safeguards. So he said that, in his own words, now there was some threat to the US steel industry, and therefore the US had to apply higher tariffs. But let's listen to Mr. Bush in his own words.
I decided that imports were severely affecting our industry, an important industry, had a negative impact, and therefore provide temporary relief so that the industry could restructure itself. That's exactly what the World Trade Organization allows for.
So, as you have heard, Mr. Bush argued that WTO indeed provides for such safeguard measures. However, back then he was accused as having bowed in to the pressure of the domestic steel industry and to lobbyists from the US steel industry, and that it was less about safeguards, less about indeed a surge of imports causing or threatening to cause injury to the domestic steel industry, but rather outright protectionism. So let's also listen to one of the chief lobbyists back in the 2000s who was in favor of such safeguards to protect the US domestic steel industry and how he justified these measures.
A fair-minded observer that would look at the amount of surge of steel that came into the U.S. from foreign producers in 98, 99, and 2000 would be hard-pressed to believe the industry was not damaged or injured, in fact devastated.
However, the US lost the case at the WTO because it did not demonstrate that there had indeed been unforeseen developments, that there had indeed not been an increase of imports, that there was also no causation, and last but not least, there was no parallelism. What is meant by parallelism? That means that investigating authorities have to show that the facts also contribute or justify the measures that they have taken. Why is it parallelism? Because it refers to Article 2 of the Agreement on Safeguards and the paragraphs 1 and 2, and it says that this notion, this requirement to show that a product is being imported into the territory in increased quantities and to have to make the determination that there is such an increase of quantities, and that it is also in Article 2 and therefore a parallel obligation. That's why it is called parallelism, and that was also lacking in the US safeguard measures on steel case. And now let's watch the reaction by the US itself to this decision by the WTO.
No, it's another in a string of deplorable decisions by the WTO from our point of view. The organization itself, we think, has an inherent bias against the safeguard actions properly brought and fully within the WTO law and certainly within American law.
Well, today the WTO issued a ruling that, while we were pleased with some aspects of, ruled against the United States on a number of key elements, and we disagree, and on those elements we will be appealing. In the meantime, the steel safeguard measures will remain in place.
Long story short, this case explains why the WTO is being under attack by the Trump administration, why the WTO is being accused of having treated the US unfairly in the past. Cases such as these. Also the numerous Syrian cases, but also the case where it lost its justification of safeguard measures on steel. So now the US feels that it has been treated unfairly because the judges are biased, or also they have over-interpreted the law, they have interpreted something into the agreement on safeguards, for example, that really isn't there. And also on a more general level, the US also feels that its sovereignty is being curtailed. It is restricted to an undue extent, and powerful states do not like to be restrained by international law. And that explains first why the US has blocked the appointment of new members of the appellate body, and second why the US is so critical of the WTO in general. And last but not least, this old case by the WTO concerning US safeguard measures on steel also explains why today the Trump administration has decided to justify its 20% tariffs on steel on the basis of the national security exception and not as a safeguard, because it would have lost again at the WTO. Last but not least, I would like to add a few words on the special rules concerning developing countries. So with such countries or imports from such countries, then the country that wants to resort to safeguard measures can only apply them to a product from a developing country if this country is supplying more than 3% of the imports of that product, or if several developing countries, all of them having less or contributing less than 3% of the import, however, if they collectively account for more than 9% of the total imports of the product concerned. So in other words, if their contribution or if their impact is negligible, then there shall be no safeguards. So in other words, there is a special protection regime in favor of developing countries, similar to the special protection regime of subsidized products from developing countries or dumped products from developing countries. Having said that, I would conclude today's session. Once again, I hope it was interesting for all of you, and in the next one I will talk about intellectual property rights. For the time being, however, depending on the time and date you're watching this, I hope you're having a great start in the day, a great rest of the day, a great evening, or a good night. Bye everyone.